Regulation 5.3, though facially neutral, indirectly discriminates against atypical unions, such as the relationship between non-heterosexual partners, which have not been recognized by the state. Queer marriages have not been recognized by the state, and queer persons in atypical unions cannot yet enter into a marriage which is recognized by the state. Though the additional criteria prescribed by the adoption regulations would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child has the adoption of marrying to meet the eligibility criteria for adoption. However, this option is not available to queer couples. When Regulation 5.3 is understood in the light of this position, a queer person who is in a relationship can only adopt in an individual capacity. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. The law cannot make an assumption about good and bad parenting based on the sexuality of individuals. Such an assumption perpetuates a stereotype based on sexuality that only heterosexuals are good parents and all other parents are bad parents, which is prohibited by Article 15. This assumption is not different from the assumption that individuals of a certain class or caste or religion are better parents. In view of the above observations, the adoption regulation is violative of Article 15 for discriminating against the queer community.